Good morning, folks. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels. Now, we're getting started this early, folks, because there's going to be probably more than just one video this morning, and I decided I really needed to have that extra dose of caffeine. Ooh, today's going to be stressful. But, anyways. Before we get started, folks, just a few of the usual reminders. As always, the articles that we are going through will, as always, be linked in the description, as well as the first video that kicked all these other ones off about the JRC, and including the Shut the Judge Rotenberg Center Down petition. If you have not already signed it, please do. Now, folks, it's just a little past 5:30 a.m. in the morning here. So if I butcher any legal jargon, if I stumble over any of my words, I do apologize in advance. So, to get started, we are starting today. As you've guessed it, this is regards to the Judge Rotenberg Education Center Incorporated versus U.S. Food and Drug Administration. We are starting Section 2, Legal Standard. Under Federal Rule of Civil Procedure 56, summary judgment shall be granted if movement shows that there is no genuine dispute as to any material fact, and the movement is entitled judgment as a matter of law. Fed R. CIVP 50A. In FOIA cases, remember that is Freedom of Information Act, summary judgments may be granted on the basis of agency affidavits if they contain reasonable specificity of detail rather than merely conclusory statements, and if they are not called into question by contradictory evidence in the record or by evidence of agency bad faith. Judicial Watch Incorporated versus U.S. Secret Service. 726 F3D 208 215, blah, 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 blah. You can read it in the description, folks, if you want to get those details. An agency is entitled to summary judgment if no material facts are in dispute, and if it demonstrates that each document that falls within the class requested either has been produced or is wholly exempt from Act's inspection requirements. Quoting Garland versus CIA. Most FOIA cases will be resolved on summary judgment. And you can see where it's referencing there. FOIA was enacted to promote the broad disclosure of government records by generally requiring federal agencies to make their records available to the public on request. DeBacco versus U.S. Army, to balance the public interest in governmental transparency and legitimate governmental and private interests that could be harmed by release of certain types of information. United Text Corp versus U.S. Department of Defense. Okay, so that's interesting. It looks to me like the JRC is looking out for their own ass again. Surprise, surprise, right? Look at the wording that their lawyers went ahead and used with that. When legitimate governmental and private interests that could be harmed by release of certain types of information. So that private interest will also be the JRC. And what they are saying is the types of information that got released were damaging to the JRC. But here's the thing, folks. When you are abusing disabled students, you need to be exposed. People have the right to know what they're signing their kids up for when they get placed inside this school. The people who are placing them inside these schools, like, for instance, caseworkers, judges, what have you, they need to know exactly what they are subjecting those kids through the moment that they sign the paperwork. This whole but it harms us. You just don't understand. Don't understand my ass. I've worked in the field, okay? Which is going to feature in another rant of mine this morning, but we'll wait for that. Don't understand my ass, okay? You keep telling us we don't know the full situation, but say we did know the whole situation. What situation, knowing the full situation, would ever make us think that shocking someone at a rate 10 times more powerful than a police taser is ever correct for any situation, especially when we're talking about vulnerable people with disabilities who, due to the courts, literally have no legal right to go anywhere else. Where do they have to go? Where do they have to escape to? Yeah. Moving on. FOIA has 9 exemptions set forth in 5 USC blah blah blah, which are explicitly made exclusive and must be narrowly construed. Again, it's this idea, and we've seen it with AH. With this, they want certain information excluded so that they look better to the public eye. They don't want the public to know what's going on, which is very interesting. If they believe so much that their treatment is helping these kids, you would think they would want it shouted to the moon. So why are they fighting continue to use devices on one hand and yet fighting so hard to keep certain information behind locked doors? You would think they would want absolute transparency, right? Yeah. Anyways, these limited exemptions do not obscure the basic policy that disclosure, not secrecy, is the predominant objective of the Act. The FOIA authorizes federal courts to enjoin the agency from withholding agency records and to order production of any agency records improperly withheld from the compliant. Okay, so you want your records withheld, but you want the FDA to produce everything. Really? And why should they, considering literally everything they've gone over with this case is a matter of public record and can actually be found on their websites? Quotations, names of articles, the people who testified, what they said, everything. Everything. Please. Moving on. District courts must determine de novo whether non-disclosure was permissible. Really? Okay. Whether or not, they're trying to basically say that the Non-Disclosure Act, attorney-client privilege, whether it was permissible or not. Really? So the people speaking against you don't deserve protection? Wow. I mean, I know I shouldn't be surprised with the JRC, but I don't know. It's kind of early. Not looking my best today. Kind of like out of reasons to care. Every once in a while, you have to go sans makeup and, not be the doll for once. Anyways, when the sufficiency of release of information under the FOIA is challenged, the agency has the burden of showing that requested information comes within an FOIA exemption. They already showed the information. Karen, what else do they want? The blood of their children? This burden does not shift even when the requester files a cross motion for summary judgment because the government ultimately has the onus of proving that the documents are exempt from disclosure. Um, I was pretty sure that the law did, but like, what are we retrying the concept of attorney-client privilege now? Well, the burden upon the requester is merely to establish the absence of material factual issues before a summary disposition of case could possibly occur. So, as you can see, pretty fired up this morning. Obviously. And yeah, it's this whole idea behind what I'm seeing right here is you don't get to air all our dirty laundry, but how dare you not produce your own? And number two, this idea of that the FDA hasn't already provided everything for public consumption under their regulation side of their website. They have. Which reminds me, that's where I need to go digging for the FDA hearings. I will probably definitely be getting to that after we finish up with this. But anyway, folks, context is this is the whole idea of we get to hide certain things, but you don't. You have to provide all this information that you've already provided. It's a crapshoot, folks. It's a waste of trees. But what can we expect with the JRC? All of this, all in the effort to convince the planet that torturing disabled children is necessary. Wow. Just wow. What a world, huh? This is why we fight this crap, folks, because these people don't even see how hypocritical and how evil what they do is. You either have the true believers, the profiteers, or the truly sick that stand behind such a group like the JRC. There is no in between, no ifs, ands, or buts. And for me, there's only one side, and that's the side of the victims. Period. But, anyways, I'm going to go ahead and close this out because we have probably at least another video to do if I don't go ahead and do another one as well. So, as always, folks, I do appreciate your time this morning, and I will be seeing you in the next few minutes. Hope you have a good one. If this is the only videos you see, bye-bye now.